George Washington is quoted as saying, "Government is not reason, it is not eloquent, it is force. Like fire, it is a dangerous servant and a fearful master." But what did he mean by that? Well, we all know the wonderful things we can do with fire. We cook with it, warm our houses with it, we dispose of unwanted debris, we use it in industry, we make s'mores around the campfire with family and friends, and many other wonderful ways that have changed our society and world. It is a very necessary force, for without it, society cannot thrive. But fire can become one of the most devastating things that anyone could witness. It can destroy whole forests, render people homeless, disfigure or kill us, and spread untold misery if left unchecked. Government is very similar to fire. We utilize it to keep order. We use it in emergencies and to ensure justice in our society. In short, government is very necessary for society, if it is utilized in the proper way. But left unchecked, government can wreak far more devastation on our world than any plague or natural disaster could ever hope to accomplish. In fact, the greatest cause of death in the 20th century was by government. Now, government is nothing new. Man has always set up some form of rudimentary government to govern their society. But as civilizations rose and fell, knowledge was gained as to what form of government worked and what did not. And this was based on learning from the mistakes of the previously failed civilizations, analyzing what their downfall was, and making the necessary changes to one's own government so as not to follow down the same destructive path. The ancient Greeks initially regarded the best form of government as rule by the best men. Plato advocated a benevolent monarchy ruled by an idealized philosopher king who was above the law. Plato nevertheless hoped that the best men would be good at respecting established laws, explaining that where the law is subject to some other authority and has none of its own, the collapse of the state, in my view, is not far off. But if law is the master of the government and the government is its slave, then the situation is full of promise and men enjoy all the blessings that the gods shower on a state. More than Plato attempted to do, Aristotle flatly opposed letting the highest officials wield power beyond guarding and serving the laws. In other words, Aristotle advocated the rule of law. In Aristotle's work, Politics, he stated, "It is more proper that law should govern than any one of the citizens. Upon the same principle, if it is advantageous to place the supreme power in some particular persons, they should be appointed to be only guardians and the servants of the laws." According to the Roman statesman Cicero, we are all servants of the laws in order that we may be free. During the Roman Republic, controversial magistrates might be put on trial when their terms of office expired. Under the Roman Empire, the sovereign was personally immune, but those with grievances could sue the treasury. In China, members of the school of legalism during the 3rd century BC argued for using law as a tool of governance, but they promoted rule by law as opposed to rule of law, meaning that they placed the aristocrats and emperor above the law. In contrast, the Huanglo school of Taoism rejected legal positivism in favor of a natural law that even the ruler would be subject to. In Islamic jurisprudence, rule of law was formulated in the 7th century, so that no official could claim to be above the law, not even the caliph. And finally, in 1215, Archbishop Stephen Langton gathered the barons in England and forced King John and future sovereigns and magistrates back under the rule of law, preserving ancient liberties by the Magna Carta in return for exacting taxes. This foundation for Constitution was carried into the Constitution of the United States. So as you can see, the concept of the rule of law is not actually the origin of one country, but the embodiment of the gradual foundation of government through the ages. Now, the term rule of law is an ambiguous term that can mean different things in different contexts. In one context, the term means rule according to law. No individual can be ordered by the government to pay civil damages or suffer criminal punishment except in strict accordance with well-established and clearly defined laws and procedures. In a second context, the term means rule under law. No branch of government is above the law, and no public official may act arbitrarily or unilaterally outside the law. In a third context, the term means rule according to a higher law. No written law may be forced by the government unless it conforms with certain unwritten universal principles of fairness, morality, and justice that transcend human legal systems. So where does the Constitution fall? Well, actually it falls under all three of these meanings. In the first instance, under the example of no individual can be ordered by the government to pay civil damages or suffer criminal punishment except in strict accordance with well-established and clearly defined laws and procedures, this is where the Bill of Rights comes in. The Bill of Rights being the first 10 amendments of the Constitution. For example, our Fourth Amendment is quite clear and it has strict accordances and clearly defined laws and procedures. The government is not allowed in or on private property unless they have a warrant. And the amendment goes further to even spell out what exactly that warrant must consist of. The other amendments are equally clear and exacting in the descriptions. So our Constitution meets this criteria. So what about the second definition of rule of law, which is rule under law, which means no branch of government is above the law, and no public official may act arbitrarily or unilaterally outside the law? Well, let's explore this a little more by identifying what we are here in the United States. We are a republic. But there are also 50 sub-sovereign state entities that are referred to as republics, or which have governments that are described as republican in nature. This is because Article 4 of the Constitution guarantees to every state in this union a republican form of government. So what is a republic? A republic is a form of government in which the affairs of the state are a public matter, not the private concern of the rulers, in which public offices are consequently appointed or elected rather than privately accommodated, usually through inheritance or divine mandate. And though we don't think of our state in these terms anymore, when the Constitution was ratified, and even today, your state was your country. That too is important when understanding some of the terminology and design of the Constitution. This is how the ratifiers viewed the construction of the Union. Today, many of us are told that we are a democracy. We are not. And this is a very important distinction, because in a democracy, the majority make the rules. It is also known as mob rule or rule by the mob, and this is completely incompatible with a republic or with the concept of the rule of law, where a set of guiding laws and principles is what all other laws and rules stem from. So back to the second definition of rule of law, which is rule under law, which means no branch of government is above the law, and no public official may act arbitrarily or unilaterally outside the law. Well, this is true as well. In the United States, all government officers, including the President, justices of the Supreme Court, and all members of Congress, state legislatures, and all executive and judicial officers pledge first and foremost to uphold the Constitution. This is called for in what is known as the Oath Clause of the Constitution. Article 6 of the U.S. Constitution states, "The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution." These oaths affirm that the rule of law is superior to the rule of any human leader. In this way, a fixed set of rules will be the guiding principle for the nation. The Constitution was also created with an amendment process that was challenging. The founders understood human nature and the tendency of us to want to change things to suit our own purposes. So let's explain that further. The Constitution is the guiding principle. It is superior to any laws that are made by Congress or any treaties that are signed affecting the United States. In fact, if Congress makes a law that is outside of its enumerated powers, or constructs and signs a treaty that is not in line with the Constitution, it is not actually a law at all. You can think of these more as illegal federal actions, and they have no binding power on the states or its people. The President, as the executive branch of the government, is responsible for carrying out or executing the laws that have been put forth by the legislative branch of government, or Congress. However, if the President takes actions that are outside of the scope of the Constitution, through executive orders or some other means, or tries to carry forth measures that are outside the Constitution, these actions are to be ignored. This is what makes the rule of law different from other forms of government. The rule of law is superior to anything that the power-hungry or ignorant try to enforce on the people. The legislative branch does have some discretion. It is free to decide what statutes it will write, as long as it stays within its defined, enumerated powers and respects the constitutionally protected rights of the individuals. And remember, only the legislative branch has the authority to create law, because it is the direct voice of the people through their representatives. If the executive branch, the President, is allowed to make law, then we are a monarchy. If the judicial branch is allowed to make laws, then we are an oligarchy, which is ruled by a few. Here's what that would look like. The Constitution acts as a sort of a filter. Only laws that fall within the confines of the Constitution can be considered. Those that do will be passed to then filter down to actually affect the people and society. Laws that do not fall within the confines of the Constitution shouldn't see the light of day, and their drafting for consideration should possibly cast doubt on the drafter's allegiance to his oath. Everyone in the country wants some form of legislation passed, because everyone has some ideal way they think society should function. If you don't think that's true, think to yourself how often people say things like, "You know what you ought to do?" or "We need a law to..." This can take the form of gun control laws, anti-child labor laws, farming laws, healthcare laws, environmental laws, and so on. It can also take the shape of some very restrictive and crippling laws, laws that help restrict competition and consolidate power, or laws that extract additional taxes for people's or companies' pet projects. The one thing that all laws have in common is that they all seek to enforce a particular point of view, extract money from people, or make other people conform to some form of norm. So the Constitution is the test of whether a law is constitutional or if it isn't. If it does not align with the Constitution, then it is not a legitimate law. This is regardless of whether the bill was killed in Congress or whether it passes and is signed into law. It is still unconstitutional and hence illegal. The federal government has stepped outside of its clearly defined boundaries and must be pushed back into them. Here's what that looks like in practical terms. Every person who takes the oath to protect and defend the Constitution of the United States is responsible for defending it, even if the level higher is the one breaking it. In this way, there are multiple checks placed on federal power. Ultimately, if all of these checks that were placed in the Constitution fail, then the final responsibility will fall to the people in the form of jury nullification. This is when a jury of one's peers refuses to convict anyone under an unconstitutional law. The key to success of the system that was set up by the framers working is that everyone must understand how it is supposed to work. In the Virginia Ratifying Convention, Governor Edmund Randolph spelled out what was to be understood by the oath. The senators and representatives, members of the legislatures, and executive and judicial officers are bound by oath or affirmation to support this Constitution. This only binds them to support it in the exercise of the powers constitutionally given it. In the North Carolina Ratifying Convention, when speaking on the state's officers' oath to the Constitution, Archibald McLean stated, "The officers are only to be sworn to support the Constitution, and therefore will only be bound by their oath so far as it shall be strictly pursued. No officer will be bound by his oath to support any act that would violate the principles of the Constitution." And finally, James Iredell in the North Carolina Ratifying Convention stated, "It has been objected that the adoption of this government would be improper, because it would interfere with the oath of allegiance to the state. No oath of allegiance requires us to sacrifice the safety of our country. When the British government attempted to establish a tyranny in America, the people did not think their oath of allegiance bound them to submit to it. I had taken that oath several times myself, but had no scruple to oppose their tyrannical measures. The great principle is, the safety of the people is the supreme law. Government was originally instituted for their welfare, and whatever may be its form, this ought to be its object. This is the fundamental principle on which our government is founded. And remember, your state was your country. The terms were synonymous." Now, there are many other examples that I could give of this understanding of the oath, but for brevity's sake, I'm going to move on. Now, one of the things I do want to point out is that these gentlemen weren't just some guys off the street. These were the guys who would understand what the Constitution's limits were. Edmund Randolph was one of the ones that, as a delegate at the Constitutional Convention in Philadelphia, had a hand in crafting the Constitution. And James Iredell was the leader of the entire state of North Carolina's Federalists. These are the ones who were pushing for the Constitution's adoption. So these gentlemen, as supporters and crafters of our present Constitution, were explaining to the people of the states exactly where the limits of the Constitution were. And these explanations and reassurances were the reason the Constitution was adopted. So with that in mind, does the Constitution fit the second definition of the rule of law? And the answer is yes, it does. So does the Constitution fit the last definition, rule according to a higher law? This means no written law may be enforced by the government unless it conforms with certain unwritten, universal principles of fairness, morality, and justice that transcend human legal systems. Well, this is not necessarily written into the Constitution, but our nation is founded on the principle of a higher law. This was spelled out in the Declaration of Independence when it was stated, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. This higher law is what is known as natural law. Natural law is the understanding that rights are the inherent possession of men and not the gifts of government. Our founders read the work of John Locke in their study on natural law, 2 treatises of government. Locke's second treatise is where he outlines and explains in detail the foundation of natural law. So while the Constitution may not perfectly fit this definition of rule according to a higher law, we were surely founded on that principle. So for this reason, I put a check mark by it as well. Now, it is important for people to understand that the Constitution was written specifically to bind the federal government and keep them from stepping outside of the enumerated powers given to it. Is it any wonder that we're in the mess we're in today? The Constitution isn't taught in our schools. Our police officers don't know it and aren't taught it in their training. Our state legislatures don't know it or show any competency in it before they are allowed to take office. Our county officials don't know it or show any competency in it before they are allowed to take office. Our city officials don't know it or demonstrate any competency in it before they are allowed to take office. And our citizenry is far too busy with more important things than to learn about it. So is it any wonder why our nation is in the shape that it's in, when our founding document is all but unknown in the country that is to utilize it as its guiding principle? When people say there are defects in the Constitution for the mess we're in today, that's not really a fair statement. Is it the Constitution's fault that we are ignorant of how it works? Just as the man on the left is utilizing the ladders incorrectly, does that mean there's a defect in any of the ladders? If something is utilized incorrectly, you can expect to have trouble. Thomas Jefferson stated, "Though written constitutions may be violated in moments of passion or delusion, yet they furnish a text to those who are watchful, that they may again rally and recall the people." And that's what we have to do. The solution is actually very simple, though its implementation will take all of our efforts. We need to begin to learn our founding principles and the document that laid them down for us. We then need to pass this knowledge on to others and hold them accountable. We must be sure and elect people that fully understand the Constitution and who will be faithful to it and defend it. And we must make sure that the Constitution is our gauge, and not what party someone belongs to or that we are affiliated with. We can fix the problems that we are facing, but the solution is going to have to start with us first.